Good morning, everyone. We will begin in just a moment. We want to allow time for all of our attendees and panelists to join today's webinar. So we appreciate your patience while we kind of wait for things to get going. We should be starting in about 3 minutes approximately, but we'll give it time to make sure all of our panelists can be able to join. Good morning, everyone. Just a reminder, we will begin in just a moment. We're still allowing some time for all of our panelists to join us. So we appreciate your patience as we wait for all of our attendees and panelists. Good morning again. We are still waiting for some of the panelists to join us today. I'm curious for any of our RAC members, have you heard from any of our missing RAC members of whether they'd be able to make it or not?
Yeah, I think Katie is unfortunately not able to make it. She's at a different meeting at this time.
Gotcha. Appreciate it. Thank you.
Sorry, just to say she might make it for part of it. Yeah, depending on when this other thing ends.
I think Jenny and Amanda are both, I think, unavailable. I haven't heard specifically from Amanda. And I haven't heard from Jajetta.
Okay, gotcha. I'll give it a couple extra minutes just because I want to offer anybody the opportunity to get started, and then we'll get started. But I also know that everybody has limited time frames. So we'll go ahead and get started about like 10:07, just to give everybody 2 more minutes, and then we'll get this webinar moving. Thank you both for your input. All right. Welcome, everyone. I appreciate the patience today. I know that we're starting a little bit late, but I wanted to make sure that we offered enough time for all of our additional panelists to join. But we're going to go ahead and get started because we don't want to delay too much. Today is Wednesday, October 1st, and it is 10:07 a.m. This is the Rulemaking Advisory Committee meeting, or RAC meeting, for the Batch 14 Paid Leave Oregon Proposed Administrative Rules that relate to benefits, equivalent plans, contributions, and appeals. This meeting is now in session and it is being recorded to create an official report. My name is Jacob Harpart, and I am a policy analyst with Paid Leave Oregon and will be serving as the hearings officer for the Oregon Employment Department during this Rules Advisory Committee meeting. Also with us today is Tiavan Sievers. She is the lead policy analyst here at Paid Leave Oregon, and she will be leading up today's discussion. Everyone's microphones are currently deactivated except for the RAC members and OED staff. RAC members, if you need to step away, please make sure your microphone is muted. For everyone else observing the meeting this afternoon, please only use the chat feature if you are having technical issues. Our staff will be putting various links and information in the chat for your reference as we go along today. The Q&A feature is available for the public to use to ask questions or to sign up to speak during the public comment period if time permits. Today's RAC meeting is scheduled to run from 10 a.m. to 11:30 a.m., and we will be discussing the Batch 14 proposed administrative rule changes. The primary purpose of this RAC meeting is to have a discussion prior to the formal rulemaking process with our RAC members regarding the rule changes. RAC meetings are open to the public, and we may take public comment at the end if time allows. Additionally, we will also accept written comment from our RAC members or the public for a couple of days after this meeting. We will touch on this a little bit later in our presentation on how written comments can be provided. After all RAC member feedback is reviewed by paid leave staff and any changes are made as appropriate, we will move forward with the Batch 14 formal rulemaking process, which will include 2 public hearings. At this time, we are going to want to introduce our Paid Leave Oregon Advisory Committee members. These are the current RAC members for the Paid Leave Oregon Administrative Rulemaking process. RAC members, we ask that when you introduce yourself, you turn on your camera and state your name, and that once you are finished, you mute your microphone and when you're not speaking. We're going to start with Anna Richards Roberts. And once you have introduced yourself, will you please call on the next RAC member, please?
Sure. Hi, my name's Anna Richards Roberts. I work for SEIU Local 49, mainly working with janitors here in Oregon. And I'll call on Delina.
Good morning, everybody. My name is Delina Binyam, and I am the Reproductive Justice Manager for Family Forward, and I will pass it off to Odalise.
Hey y'all, good morning. Odalise Aguilar, she, her with Oregon AFSCME, and I'll pass it over to Paloma.
Good morning, Paloma Sparks with Oregon Business and Industry.
Okay. Thank you all. Just checking, it looks like that's all of our RAC member attendees today. Thank you for introducing yourself. We appreciate your time today. So now I'm going to pass the presentation over to Tiavan, who will describe the 23 proposed administrative rule changes. These changes include 2 rule adoptions, 20 rule amendments, and 1 rule that is being repealed. Tiavan will also provide an opportunity for the RAC members to have some discussion and give feedback for each rule included with this batch. Once the 23 rule changes have been presented and discussed with our RAC members, we will move to the public comment period, time permitting, and we'll end with talking about the next steps in the rulemaking process. Over to you, Tiavan.
Yeah, thank you, Jacob. So before we begin discussing the draft rules of this batch today, I'm going to give a quick overview on where the Paid Leave Oregon program stands on administrative rules currently. So at the beginning of this year, we adopted our batch 12 rules, which included 8 rule changes. And then earlier this week, we filed 2 temporary administrative rule amendments related to appeals, which we refer to as batch 13. These temporary rule amendments become effective today, October 1st, 2025, and they will then be made permanent as part of the batch 14 rules, which we are discussing today, which will become effective on January 1st, 2026. Currently, the department has a total of 121 permanent administrative rules, ranging from topics related to benefits, contributions, equivalent plans, appeals, and all of Paid Leave Oregon's rules can be found on the Secretary of State's website, which we will post a link to their website in the chat for this meeting. As Jacob noted, the batch 14 proposed rules include 2 proposed rule adoptions, so new rules, 20 proposed rule amendments, and 1 proposed rule repeal. These rule changes are due to program needs and also the 2025 legislative session. The goal is to make these proposed rule changes permanent, as I mentioned, with an effective date of January 1st, 2026. You can find all approved final rule language on the Secretary of State's website. And in the chat, you can locate a link to the Secretary of State's website, which contains a current list of all the permanent administrative rules. The compilation of the batch 14 rules that we're discussing today were emailed to the RAC members, and they're also posted on our Paid Leave Oregon website. I'm going to walk through and briefly explain each of the rules and the changes we're making. I will pause after each rule to have discussion and receive feedback and suggestions from our RAC members. Before I get started, I just wanted to note that you will see 3 colors of text on this compilation document. Red text shows the changes to the rules that we're making as part of batch 14. So that's added, amended, and removed language. Black text is existing text that will not be changed. And then purple text shows the language that was changed during the batch 13 temporary administrative rules I just mentioned, which are being made permanent as part of batch 14. And I just wanted to point out that we also corrected a couple of typos in the track changes. So in case you noticed them in the emailed version of the compilation you received. Okay, I will get started. And the first rule that we're amending is OAR 471-070-0001. And this rule is being amended to remove language stating that all Paid Leave Oregon rules are contained in Chapter 471, Division 70. And the reason for this follows Senate Bill 69, which was passed in this past legislative session, which assigns rulemaking authority for oversight of job protections, retaliation, and discrimination to the Bureau of Labor and Industries, BOLI. And so since they will be passing a rule related to job protections, not all paid leave Oregon rules are in our chapter at this point, or will be come January 1st. Any comments from RAC members on this change? If not, I will move on. The next rule that we are amending is OAR 471-070-1000, which is our definitions rule for benefit. This rule is being amended to add a definition for in loco parentis, which is the term that is used in our statute. And so we're clarifying how this term is being applied. We're also updating the definition for average weekly wage. So the effective date aligns with the effective date used by Oregon's unemployment insurance program. And we're adding a definition for electronic signature as well. And welcome any comments or feedback.
I just had a clarification on the definition of in loco parentis. This could be, just obviously thinking as, we have a lot of folks, right, whose parents are being detained. It's not like you don't have to have multiple of these, right? It's like if you're suddenly the person taking care of the kids because, mom and dad have either been detained or deported, then you could be the in loco parentis without like meeting more than one of these criteria. Like, does it have to be more than one? I guess is my question.
So we will basically be looking at these together. So it doesn't mean that, as it says, there's no one factor that's like determinative necessarily. So we will look at these together, and then we will also look at the documentation, which we will touch on later. And so if, that shows, okay, this person is taking care of this child in an in loco parentis relationship, then we would, approve them. But so it doesn't necessarily mean it's like one of these is determinative, or it has to be 2 or 3 or 4. We'll just look at the circumstances altogether.
Okay, thanks.
Right. If there are no more, if there's no more feedback on the definitions, then I will move on to the next rule, which is OAR 471-070-1010, which relates to eligibility and qualifications for benefits. We are amending this rule to clarify that pre-placement leave is limited to 12 weeks per child, and that additional pregnancy leave can only be taken once per pregnancy, regardless of the number of children carried. This was already mentioned in the rule, but we are clarifying this in the example. Okay, if there's no feedback for that rule, then I will move on to the next, which is OAR 471-070-1110, which relates to the verification of family leave to care for and bond with a child. And so the purpose of this amendment, there are a couple changes here. The first one is to ensure that the verification requirements for bonding leave reflect the full range of legally recognized documents used to establish paternity or guardianship in Oregon. So as you will see here, we are, referring to documents slightly differently than before. And we are also clarifying how a claimant may show an in loco parentis relationship with a child. And so, as I just mentioned, there are different ways in which a claimant can, show on documentation that they actually have an in loco parentis relationship. And then lastly, we're also clarifying secondary documentation requirements regarding the name of the child. Previously, in this rule, the way the language was written, it basically sounded like the name of the child is always required, which is not the case. And so we're clarifying that.
I just had, when we Can we go back to this section right before this where we're still talking about adoption, but the documentation required?
Oh,
Yeah.
this one?
Child support division. I that feels like it could become problematic, because that's not about custody. It's just about child support. So you could have somebody who owes child support and has paternity, but who has no custodial relationship with the child.
As far as our research has basically shown that the documents issued by the Department of Justice Division of Child Support establish paternity or guardianship in some cases. I mean, I definitely see your point, that it doesn't always necessarily mean this, but that this is something that is a legally recognized document that can be used to establish paternity or guardianship. And the way that this was written before, it only referred to court-issued documents. And so there are also these administrative orders issued by the Department of Justice Division of Child Support that can also show that paternity or guardianship is present. So do we just wanted to include those as well so they're not excluded? But of course, it depends on the circumstance, whether that actually establishes paternity or guardianship or not.
Yeah, I'm just worried about non-custodial parents getting in the middle of custodial parents' requests, but I will
Yeah.
defer that to a later conversation, I'm sure.
Yeah. We can definitely note that. Okay. Are there any other comments or feedback on this rule? Okay, I will then move on to the next rule, which is OAR 471-070-1120, which is around the verification of a serious health condition. And so this rule amendment clarifies that documentation must be signed by the patient's healthcare provider when the claimant is requesting leave to care for a family member, and then also updates the required information to include the patient's date of birth when different from the claimant. So these things were previously not clarified, that the healthcare provider must be the one treating the patient, and that we also need the patient's date of birth, since that's not something that we have as part of the application otherwise. Okay, then I will move on to the next rule we're amending, which is OAR 471-070-1130, which relates to the verification of safe leave. We're amending this rule to clarify that verification documentation for individuals claiming safe leave must either include the name of the survivor or the name of the child when the leave is being taken for the child as the survivor. Previously, it required the documentation to have both names, which is not, in reality, not always the case. And we are always also clarifying that secondary documentation is required to establish a family relationship when not shown by the primary documentation. And then also similar to the bonding leave rule we already talked about, we are amending the rule to clarify how a claimant may show an in loco parentis relationship with a child. Any feedback on this rule? Okay, then I will move on to the next rule, which is OAR 471-070-1250, which is the claimant designated representative rule. And so we are amending this rule to remove provisions related to representation of an incapacitated claimant, which was previously part of this rule. And those provisions will be moved to the rule I'll be discussing next, which is 1260, and combined with provisions related to representation of deceased claimants. And so this follows the passing of Senate Bill 858 in this past legislative session.
I have a question just regarding the thought process behind only recognizing one individual and restricting it just to one individual, simply just because like I'm imagining like if parents are having to like navigate when it comes to care and making this decisions in general. If only one parent is recognized, but then something happens with that said parent, they're not available for some reason, and another parent comes in, does that mean that they are not, or in this case, like especially if they're custodial or like if they're foster parents, does that mean that that other parent wouldn't be able to be recognized as a representative of the claimant? Yeah, just needing some clarification on that.
Yeah, no, that is a good point. At the moment, yes, we are only recognizing one representative at a time. So that would not include both parents, for example, in the example that you are providing. The reason for this was well, there are a couple of them. One was related to concerns, that potential fraud concerns in some cases, and also administratively, there were some challenges to having multiple representatives like being present at the same time. But I do appreciate that, especially in the case of parents, that could pose a problem if somebody wants to represent their child. So I think this is definitely something that we will note and take back as feedback. So thank you. Anna?
Yeah, I just to add, I mean, to Delina sort of asked that as a clarifying question, but I think you guys, you did a great racial justice statement this time, right? Talking about how, low income and immigrant families, just have a harder time navigating bureaucracy. And so then when you start adding stuff like, only this person and not this other person, so then that person suddenly has to go back to Mexico, right? And then how are you, managing that is, I don't, I think you need to think about what you're weighing here as your values, and how those affect low income folks, frankly, and barriers to access for this program. And I mean, just sort of to foreshadow, I would say the same thing for, if I'm understanding this correctly, someone's alive and you're the person that they've designated, or you've gone through all the hoops to be designated to speak on their behalf, right? Which is a barrier, again, to folks who don't speak English, right? And who aren't good at computers. And then the person dies, and then there's a whole new bureaucratic process while they're also trying to deal with like burying somebody or dealing with funerals and all that then they have to go through again in order to get the rest of the money. I think this is a place where you need to think, you need to look at the equity lens a little closer.
I can definitely speak to, so I will move on to the next rule in a second, and I can speak to what you're referring to here, because we did actually thought about this quite a bit, and unfortunately we have some limitations what we can and cannot do legally around for deceased claimants. But I just wanted to reiterate for the requirement that we're only recognizing one claimant. Again, I think this is a really good point, and we'll take this back and reevaluate that piece. And I can then also move on to the next rule, which is OAR 471-070-1260, which is describing the process for an authorized agent of an incapacitated or deceased claimant. And so we are adopting this rule to implement statutory changes that are made or were made as part of Senate Bill 858, which authorize representatives of incapacitated and deceased claimants to act on their behalf, and basically providing that OED must establish the requirements under which somebody can be designated. And so we already had the requirements for an incapacitated claimant in place previously, so those have not changed. Those are the same as before, and we're adding the requirements for a deceased claimant. And I want to speak to your first point, Anna, in terms of requiring that somebody actually has to renew the representation. Without with regard to that, unfortunately, it is the case that when somebody passes away, the designation that they had previously expires at the date of death. So legally, if somebody was a representative, once that person dies, because they're no longer alive, they basically need to renew that. And so that is some feedback that we did get from the Department of Justice, for example. And so with regard to that, unfortunately, we will have to ask the person to go through the process again. And then the other question I think that you are touching on is that we are currently restricting who can request to be the representative of an or a deceased claimant, sorry, to individuals that are listed in ORS 293-490, which is like list of blood relatives, close blood relatives, and the trustee. And the reason that we are proposing this direction is that we are required, if there isn't an executor of an estate or somebody else who's authorized by probate court, that we are legally required to issue payments to the individuals in that statute. So they're the survivors that can actually receive benefit payments. And so the people, if we basically don't have this restriction, we could have a scenario where somebody requests to represent a deceased claimant and they submit the claim, they go through the whole process, but if they are not on that list of individuals, they are not actually able to receive the benefit payment. And so we know that, somebody who is representing a deceased claimant and completes the process, they often rely on these payments because they're in a difficult situation, to receive them for their loved ones. But currently, as it stands, we are legally required to only issue payments up to $10,000 to the survivors on that list. And so that is the rationale here for this restriction, I guess.
Okay, and just pragmatically, if someone dies in the middle of a week, like, how do are you guys like splitting it up day by day or like in the middle of the same week?
Yeah, so the representation expires on the date of death. So it ends on the date of death. And so if somebody, is already approved for benefits up to that point, up to the date of death, that would go through the same process as we have for an incapacitated claimant or claimant designated representative, and then starting from the date of death, like a new process or a new representation would have to be put in place and then processed. So. Any other feedback on this rule? I know it's a new rule, so there's a lot of new text here. All right, if there is not, then I will move on to the next rule, which is OAR 47107011300, which is the written notice poster to employees of informing them of their rights and duties. And so the purpose of this amendment is to require that employers under the state plan update the model notice poster whenever a revised version is issued by the department. And this ensures that the, that employees have the most up-to-date information about the program on the poster, and that there isn't an outdated poster, still put up somewhere. Any feedback on this one?
So whenever feels a little broad. Is there going to be a specific date on which you're going to do updates?
So I think so we will, most of our materials get updated on a regular basis. So, we will look at these a couple times a year and we'll update them as needed. I think for the model notice poster, it has been updated. I don't think we expect that it will be updated, like every month or something like that. It is just to check that it's, still reflecting what we have in statute and rules. But we would also inform employers about this, probably as part of the, employer bulletin, the employer newsletter that we send out, so that there is communication that says we have a new version here, and you are, required to put this up. So it's not just, put up on the website, so that there is some, outreach also to employers.
I would feel a lot more comfortable if we had a specific date, and not just sort of whenever or, because a lot of employers, for example, you know, they do the all-in-one posters, they update it when the minimum wage changes on July 1. I
Yeah.
also think like updating the one on the wall, depending on how often you are making these updates. And if you're a small business, like I'm sure people try and make sure that they read the notices, but um that's a lot to ask of sort of every time you make a change. Especially if it's gonna be like multiple times a year.
Yeah, no, I appreciate that. And I just got the information here that our current plan for internal review is once a year.
Okay.
And outside it would just be if there are, statutory changes or rule changes that would make it necessary, but otherwise we would review it once a year. So yeah, we do not expect that it would be, frequently or multiple times a year.
There's any chance we get a line with that July 1 date? The Boley does the minimum wage? That would be awesome.
We can consider it. I don't know that which date we currently have. I can check back here with our folks, but we can definitely take that feedback back.
Thanks.
Okay, if there are no other comments on that rule, I will move on to the next one, which is OAR 47107011310. And this one relates to communication to employers and employees. This doesn't seem quite right here. I just realized, but anyway, it is about the notice that's required and the communication to employers and employees. So the rule is amended to remove language regarding the timing and frequency of the notice for consecutive and intermittent leave. The reason for this being that currently our statute, specifically OR 657B040, does not provide specific authority to actually describe requirements for different leave schedules. And so it is further, in addition to that, it's further amended to clarify that the employer must provide policy and procedures regarding the notice to all employees, not just eligible employees, because everybody should be informed about what policies and procedures are. Any feedback on this one?
Well, I mean, I would just note that this exceeds the employment department's authority to say that they have to provide it to all employees. Because that doesn't cover paid leave in this program. And that would be a statutory change that would ultimately be enforced by Boley. So pretty sure it still needs to be eligible employees, not all employees.
We can take that feedback back. I think the reasoning here was that at the time that the policy and procedures are provided, it's not necessarily already clear who's eligible and who is not, and every employee should be informed about what policies and procedures are around paid leave, even if they ultimately do not end up being eligible.
Yeah, I would agree. And I would just say what I see is just a much larger problem with people, not being told about paid leave when they take eligible leave. And then they find out about it more than 30 days later. And now they're stuck in this appeals process because of the rule that, you guys implemented, that people can't file, more than 30 days after. I think that's just a much, larger problem than, whether an employer has to inform employees about things. It's just the number of, just frankly, from my perspective, low-income immigrant workers who aren't being informed about this benefit and are missing out on it.
Okay, if there are no other comments on this rule, I will move on to the next one, which is OAR 47107001330, which relates to job protections. And this is something I already mentioned at the top, that we are repealing this rule due to statutory changes made by Senate Bill 69, which assigned rulemaking authority for oversight of job protections, retaliation, and discrimination to the Bureau of Labor and Industries, BOLI, and so we anticipate that they will be adopting a rule relating to job protections, and so this repeal will be just a reminder. This is effective January 1st, so there should be a transition at that point over to BOLI regarding this. Okay. This Paloma.
Makes sense to me. Great.
Okay, then we'll move on to the next rule, which is OAR 47107001350, which relates to an active benefit year under an equivalent plan and the benefit drawdown. So we're adopting this rule. This is a new rule to describe how Paid Leave Oregon acts on receiving information about a claimant's equivalent plan usage prior to applying for paid leave benefits. So it describes how Paid Leave Oregon draws down benefits if an employee started a benefit year under an equivalent plan. So if they were approved for benefits and took benefits under an equivalent plan prior to applying for paid leave, to prevent an employee from exceeding the 12 or 14-week leave entitlement that they have in a benefit year.
So I'm really concerned about this one, from the perspective again of sort of low-wage folks who tend to work multiple jobs. And so I want to make sure I understand it correctly, and then just understand kind of, why, if my understanding is correctly, why you would do this, right? So like a lot of times, just as an example, janitors, right, are working two jobs, two different companies. And so one might be, during the day, like say you are a lunch lady or something, right? And then, you then go to your evening janitorial job with a different company, right? And so then if you suddenly say have, an ill child who can't go to school, you may very well need to take leave from your day job, but then the older sister gets home and can take care of the kids so you can go to your second job, right? And so and I might not be understanding this correctly, but it seems to me like then you say, okay, great. I'm not trying to take any more benefits than I need to. I'm trying to, triage with other family members. I'm just going to take my leave from my school lunch, program, right? And I do that while my kid is sick and staying home. And let's say the school lunch let's say they have an equivalent plan. So then then later on I have a baby or I break my leg or something, and I'm trying to claim benefits from my primary, full-time night shift janitorial job. I think I could have run down quite a bit, if not all of my benefit, right, from that previous job. And so then it would, if I'm right about that, then it would seem like it's not really good for any of us, including employers, if someone's like, well, heck, then, I might as well just claim for everything and just be off from both jobs, even though I don't have to, so that like I can get my full, like I can use that up since it's going to be taken away from me for future use anyways. Am I understanding how this gets counted correctly?
I'm not 100% sure if I completely followed the example. I mean, one thing is, generally speaking, obviously somebody under a state plan, if they have two jobs, they must take leave from both jobs, like on that day. So you cannot take leave from one job and not from the other. So because you cannot be working while you're taking leave. So that is one thing I was just going to clarify. The scenario here is, let's say somebody worked for an equivalent plan and started a benefit year, 3 months ago, and now they come to paid leave. They basically, from that start that they started the benefit year under the equivalent plan, because that plan is equivalent to the state plan benefits, they have 12 or 14 weeks in that benefit year, until it ends. And so if they now come to the state plan after 3 months, then we would just want to know, did you already use benefits under your equivalent plan previously? And if you did, then we will draw down the benefits that you have, because in that whole benefit year, you are not entitled to more than 12 or 14 weeks in total. So you are not, the leave taken under the equivalent plan basically counts as part of that overall leave entitlement.
So that would
is
be
the
more like
rationale
what
for
you're
this.
looking at is a time when they move employers, like they go from one employer to another employer. One has an equivalent plan and the other is part of the state plan. Then you wouldn't want them sort of double dipping because they changed jobs.
Yeah, for instance, because we also have the concept of what we call, simultaneous coverage, where somebody at the same time works for an equivalent plan employer and a paid leave state employer. And so in that case, we're not drawing somebody down because they took leave under the equivalent plan, but the benefits are prorated. They get like basically paid a prorated amount of the monetary benefit, for the state plan leave, and then the remaining leave or monetary benefit comes from the equivalent plan employer. And so that is another concept. That is not this concept, but that is if somebody is taking simultaneously, working for an equivalent plan and state plan employer, and applies for paid leave, then paid leave pays them a portion of their overall, weekly benefit, and the rest of the benefit amount is expected to come from the equivalent plan employer. What we're talking about here is that overall leave allotment entitlement per benefit year, which is for, all employment. So it's not just, you don't get 12 weeks per employer. And so if somebody already took some of that under the equivalent plan, and for example, like you said, now switches jobs, has a state plan employer, and comes to us now, then they wouldn't get the 12 full weeks at this point because they already took some leave earlier in the benefit year.
Mm-hmm.
And so we're only
because-
looking back a year, sorry, so we're not looking back 2 years, 3 years. So we're only looking back within that potential, benefit year time period.
Right. If somebody just moved jobs and was sort of more like, say, somebody who works for OAD and only has one job normally, like I get that concept. I'm concerned about what it does to people who have to work 2 jobs. Right. Like they're not trying to inconvenience both employers. They're trying to stay at work as much as possible, based on what other family members can step in and help with. Like, it seems like if they were just only taking off from one employer and not from the other, and, in order to try to be a good employee and not use the system that this, in a case where they're not moving employers, they're just now like, why would you disqualify them from taking off from the other employer? I mean, is there a way to thread that needle that's like, if you switch employers versus if you just took off from an equivalent plan employer and didn't make any use of your paid leave benefits from your other job, that you could then not lose that?
So I think this touches on a bigger problem, which is around, us not being able to currently grant hourly leave and having that requirement that leave is taken in a day from all employers at the same time. So I think that's a little separate from this rule. However, it is a problem that we are aware of. And so we are working on solutions regarding that, but that is also something that's tied to, currently we have in statute that leave can only be taken, in increments of a day from, all employers during that day. And so if that were to be changed, we would have to, it would have to come through a statutory change. So I believe that touches more on that issue rather than what we're aiming to achieve with this rule here.
But doesn't this rule make it worse though? I mean, if you've already kind of recognized that as a problem, like wouldn't this rule make it even worse, because at least there's some people who can kind of do that balance if they happen to have one equivalent plan employer and one state employer?
I mean, generally the expectation is if somebody is taking leave, they would be taking leave from all employers. But obviously, we know that doesn't necessarily always happen in the scenario that you're describing. I mean, we can definitely take that feedback back and look at whether there's maybe an equity impact that we didn't look at here. But yeah, I believe it is more. I believe this is a little separate, but we can look at whether there's actually more of an overlap like you're describing.
Yeah, I think as far as preventing someone from double dipping, I get that. I mean, that's fair. I think as far as punishing someone who's trying to be as present as possible for at least one of their employers, in the case of a family emergency and need, I think it would be great if they didn't end up being punished as a result, if there's no statutory need for you to do so. And then my other sort of question on this is like, so then another situation we have a lot with low wage workers, right, is you might have your Monday to Friday job, and then you have a job Saturday and Sunday, right? And again, that's likely from a different employer so that they don't have to pay you overtime, right? And so maybe you go in and you clean some office building on, for one company 2 days, Saturday and Sunday, and the other Monday to Friday. So then if you have to take off because, again, there's another family member who can take care of the sick child or grandparent on some days of the week, and you only need leave from one of those jobs that you're working on a different day, like, then does this then also punish you for not taking all 7 days or taking leave from both employers when you're then later trying to access leave, say, from the other employer?
I think, well, again, it depends if it's, in the same claim period,
One's
basically.
equivalent and one's state.
Yeah, because like, I mentioned if somebody, we have prorated benefits if it's the same claim period. I would say if it's a scenario where somebody first takes paid leave and then they take equivalent plan leave and then they take paid leave again, we would look at what they did take under the equivalent plan, because it's that overall leave allotment, again, that we're not trying to exceed. But I think that is what you are describing potentially, where somebody maybe started a benefit year under paid leave at one point, but now they're just taking the leave on Saturday and Sunday from the equivalent plan, and then at one point going back to paid leave. I believe that's kind of what you're describing. And so we would look at that equivalent plan leave in that case.
Well, it's more just like if you get 12 weeks and you work 7 days a week, and 2 of those days are for an equivalent plan employer, like, and so then let's say I have to take Saturday and Sunday off every week for 4 or 5 weeks, say, let's say 5 weeks. I take Saturday and Sunday off because of my injured child or something, but I'm still at my other job because that's when the older daughter can take care of the kid, right? Monday to Friday. Then when you look at that, do you say, oh, Anna's already used 5 of her benefit weeks, or has she used, 10 days out of a total of 12 times 7, or how are you counting that against someone?
I think I would want to look at that a little more, because I'm not 100% sure. For example, if somebody is taking intermittent leave, we're looking at like, okay, which days are you claiming from paid leave? Which days are you claiming potentially from another employer? But this is not really what this rule is supposed to get at. But if it's currently potentially not clear, then we can look at the rule again and revisit.
Yeah, because just to clarify, like, let's say I have a job and it's Friday and it's Saturday and Sunday. I say I need continuous leave for 5 weeks from this job to take care of my sick kid. But my older daughter can take care of the sick child for my Monday to Friday job, right? So I've told my equivalent plan employer and they have recorded that I've been off for 5 weeks straight, but I've only gotten 10 days of pay for that, right? Because it's the job that I have on Saturday and Sunday. Then, down the road, the kid gets sicker. I need to take off, I think 12 weeks for my regular job. Do you guys say, sorry, you only get 7 because you already took off 5 weeks from your other job that you work part-time at on the weekends?
So that depends. So thanks for clarifying that. Basically what we would look at in that scenario where we're looking at the equivalent, equivalent plan usage, we would look at the number of work days that somebody works on average for all employers, and that constitutes a work week. So in that case, if they work 2 days a week for the equivalent plan employer, but in total they work 5 or 7 days a week, then those 2 days that they took for 5 weeks wouldn't constitute full weeks. So they wouldn't be drawn down for full weeks in that case. It would be a portion of weeks.
And even if they had applied for consecutive and not intermittent leave from the equivalent plan employer, that would be the case? That would be
Yes.
noted somehow in
Yes,
your
because we're
system?
also, because we're
Okay.
taking into account the other work days as well. Whereas the equivalent plan employer obviously just looks at that job and the work days that they work for that employer. But we ask an employee when they come to us, how many days do you work on average for all your employers?
Got
And
it.
so they will, for example, say 7, and then we use that 7 to calculate the weeks. So if they only took 10 days, then the calculation is in rule, but basically it would be only a portion that they get drawn down by. Yeah.
Okay.
So thanks for walking through that with me. But yes, no, we wouldn't in that case draw them down by full 5 weeks.
Yeah, so then I just go back to if there's a way to thread the needle, for folks who work 12 hours a day for 2 different employers, that'd be really
And
helpful.
that again, I think is a bigger program issue, but yeah, I appreciate the point for sure. Paloma, see you ahead.
Yeah, I guess I'm just trying to understand, is this rule intended to be responsive to the requirement that benefits, so if there's multiple equivalent plans, benefits are prorated amongst the plans, or is this really more about the benefit year?
So it's about the benefit year and the usage. And so it's not so much, what I was describing with the simultaneous coverage where we prorate benefits, like you get a portion for the state plan, and then you get portions of the monetary benefit from the equivalent plan employers. But let's say somebody had 2 equivalent plan employers in the past, and they took leave from both of those employers, and we get that information, like we report that, then again, we would look at, okay, and how many days do you work on average for all employers? And we calculate the leave that they took. It would never exceed, there's an example in the rule, for example, it would never exceed a full week. So even if you work like, you took more days than a full week off from your equivalent plan employers, we would never draw you down for more than a full week, but we would look at both employers and how much leave you took from each equivalent plan employer and draw down your leave entitlement. But this is not about the monetary like proration under simultaneous coverage, which is covered under a different rule.
Okay.
I would have to look at the rule number, but yeah.
That's fine. Yeah, I mean, I guess from employers' perspective, for the most part, employers aren't going to care what benefits employees get when they go to a new employer. But I get the complexity here. I think it's probably at least something that people are going to need to sort of grapple with and dive into a little bit more to understand functionally. I will say that as an employer representative, the way that this rule is written is pretty confusing. If we can figure out a way to break it up, make it simpler, regardless of what we decide to do here, that would be my recommendation, because there's a lot going on here and there's a lot to try and follow, particularly as like a small business owner.
Yeah, I appreciate that. And it is quite complex, like as from our side, like having wrestled with this for a while too. But yeah, we can definitely attempt to clarify or to break it up more. Yeah, so thanks for that feedback. Okay, are there any other comments on this one? I know this is a lot, and this was also a new rule. And so I will otherwise move on. Also for the sake of time, even though I think the next few ones are relatively minor changes here. So the next rule is OAR 471-070-1450, which relates to benefit payment methods. We're just removing the specific reference to Relia Card Visa here. Instead of, we're just referring to, to the cards more broadly instead of referring to the specific card. Any comments on that one? And then the next one is OAR 471-070-1465, which is about payments that are due to a deceased individual and abandoned payment. We're just removing the extra space in section 1, so this is not really a change. And then the next one is OAR 471-070-2210, relates to equivalent plan application requirements and the effective date. So we're just fixing an inaccuracy in the example regarding the due date of the reapproval applications. So this was just, a small date change here because it wasn't correct previously. The next rule amendment is regarding OAR 471-070-2230, which relates to reporting requirements for equivalent plans. And so we are amending this rule to update the listed information that equivalent plan employers are required to provide on their aggregate benefit usage report. While the current rule states that the report shall include, but is not limited to, the following, we did want to, make this more clear and more transparent for employers and insurance carriers on the additional information that we are requiring as well. Any comments on that one? Okay. Then the next rule is OAR 471-070-2330, which is the equivalent plan written notice posted to employees, advising them of their rights and duties. So in this, this mirrors what we talked about earlier. The purpose is to require that employers with approved equivalent plans update the notice poster if the department makes changes to the requirements pertaining to the notice poster. So just clarifying that that is also the case for equivalent plan employers. Then the next rule is OAR 471-070-2460, relating to an equivalent plan employer withdrawals. And so we're just clarifying in this case the timeline of when an equivalent plan withdrawal becomes effective. As currently written, employers who submit their withdrawals 30+ days in advance of the end of a calendar quarter must wait until the end of the following quarter to withdraw. That wasn't the intent. The intent was just that employers must give at least 30-day notice. So if the last day of the calendar quarter is less than 30 days away, then the employer will have the withdrawal effective at the end of the following calendar quarter. If there are no comments, I'll move on to the next rule, which is OAR 471-070-3010, which is contributions for the method for determining the contribution rate and maximum wage amount. We're removing section 3 because ORS 657B150 now describes that the Social Security Index, not the Consumer Price Index, is used as the basis for adjusting the maximum wage amount. And so this, this needed to be updated.
Yeah, Rebecca, I had one thing on this. I think that what you just said makes sense. I'm just, and maybe this is dumb, but I'm confused why the whole section is cut and not just like a change from CPI to SSI.
The only reason for that is because it's already in statute, and so we are not, required to duplicate what's already in statute. So we're just removing the entire section since it's
got it.
Started there. Yeah. Then the next rule is OAR 471-070-3100, which is related to the localization of work. This was previously called place of performance. We are changing the title and rule language to align with statutory changes made to ORS 657B 175 by Senate Bill 913. So this already happened in 2023. And so we are now amending the rule because the statutory change provided more specificity than was previously the case and more closely aligned paid leave with the unemployment insurance program. And so we removed some of the details that were previously added to fill in gaps in the guidance. Okay. There are no comments on that one. I will move on to the appeals rules. Before I address the specific amendments, I did want to make you aware that all proposed amendments related to appeals are subject to approval by the Attorney General. And so they will be submitted to the AG for review following our RAC meeting. So I just wanted to clarify that. And the first appeals rule we are amending is OAR 4710708,000, which relates to the department representation in hearings. So this is, there are a couple of amendments here to comply with changes made by Senate Bill 913 in 2023 and Senate Bill 858 2025. The 2023 change was regarding appealable items, so some were added to statute. So we were aligning this list and rule here with what can be appealed. And then this is actually one of the temporary rule changes. We're removing the requirement that the Attorney General must provide approval for the agency to represent itself in paid leave contested cases. So based on the Senate Bill 858, this is no longer the case. And so we needed to take this out. Then the next rule is OAR 471070825, relating to the a late request for hearing. So we are amending this rule to clarify that all late hearing requests will be referred to the Office of Hearings and Appeals for determination. So this is previously or currently, the rule is not completely clear around like who determines good cause, and whether a late request can be accepted. And so we're just clarifying that all late hearing requests will be referred to OH. Then the next rule change relating to appeals is to OAR 471070850, which relates to the hearing itself. So again, we are amending this to align with changes to OR 657B 410, following both the passing of Senate Bill 913 in 2023, and then there were updates this year as part of Senate Bill 858 in 2025. Representatives of incapacitated and deceased claimants are now able to represent them in proceedings. So that is one change. We're also aligning the claimant designated representative with this as well, so they can also represent a claimant in a hearing if the claimant desires. And then the statutory changes directed us to set a maximum amount the representative may charge, and to describe rules or procedures a representative must follow. And so that is what this rule puts in place for both legal representatives and non-legal representatives. And then again, we're making permanent temporary rule changes to remove the requirement that we get approval from the Attorney General for department representation. Any comments on that one? Okay. All right. Thank you, everyone. Now that we have finished reviewing and discussing the proposed rule changes, we will go over the statement of need and fiscal impacts for the rules we just discussed. RAC members, the statement of need was emailed to you, and it can also be found on our Paid Leave Oregon website. And the link is on the screen and posted in the chat. RAC members, you're welcome to open up the document titled Batch 14 Statement of Need and follow along. And for attendees of this meeting who are not RAC members, you can access the Statement of Need on our website using the link that was posted in the chat. We will start with the needs for rules section on page 4. Within this section, we just provided a small summary of the reason each rule is included in this batch that we already went through just now. And then the next section of this document is the racial equity impact section. So paid leave recognizes the importance of our program for all Oregonians, but particularly for historically underserved populations who may otherwise not have access to or are able to afford time off work. And so to evaluate racial equity impacts and equity impacts in general, we address these questions. What are the racial equity impacts of these rules, policy, or decision, and who will benefit from them or be burdened by them? And are there strategies to mitigate the unintended consequences? In terms of process, in drafting this section, we first identified equity impacts for each rule and then summarized potential benefits and burdens of the most substantive rule amendments. As I just went through, some of the batch 14 rule changes were small, like deleting a word or deleting a space, and we did not identify specific equity impacts for those. However, other changes may have uneven consequences, as we already touched on, and I'll just highlight a few here. In terms of potential positive impacts regarding the rule changes related to administrative hearings, expanding who can represent an individual, and clarifying the maximum amount and the code of conduct likely benefits communities who have historically had more distrust of government processes, for example, Black and Indigenous communities, and less resources, and who've also had less resources to hire legal representatives historically. Then also clarifying the process for assuring a local parentis relationships may have a positive impact on individuals who have non-traditional family relationships, who care for children that they're not related to by blood. However, conversely, and we talked about this also, restricting individuals who can request to become the representative of the deceased claimants to blood relatives and trustees could potentially, have a negative impact on individuals who are less likely to have blood relatives who can represent them following death. Concerning the requirements around frequency and timing of intermittent leave notice, we just wanted to note that having a more ambiguous circumstance or lack of guidance could also have an impact on those who are historically underserved and under-resourced, such as undocumented workers and those whose first language is not English, because they may not feel like they can take action against their employer if the employer penalizes them based on ambiguous notice requirements. And then also the other rule that we talked about for a while for the drawdown of benefits based on previously taken leave under an equivalent plan. We do acknowledge that there's a possibility that it could negatively impact claimants with a variable work schedule because those with a variable work schedule more often work in lower earning occupations, and this impacts Black, Indigenous, and Latino families more often than white households. In terms of mitigating unintended consequences of these rule changes, paid leave applies an established equity framework to all our policy drafting, decision, and review processes. We provide ongoing anti-racism and trauma-informed training to our staff. We monitor data for potential inequitable impacts. The program is still relatively new, but we're starting to see data come in now, which is helpful. We provide public-facing resources in plain language and make them available in the most commonly spoken languages in Oregon. And we explain the program and its elements in outreach events. As we continue to provide Oregonians with access to financial stability and job security through the Paid Leave Oregon program, we will continue to review for future administrative rule changes that are necessary and impacts that those changes may have by addressing practices, cultural norms, and structural barriers that create inequities. Finally, along with writing this racial inequity impact section, we also reviewed fiscal and economic impacts of the rule changes. And so we overall concluded there wouldn't be a large fiscal or economic impact caused by these rules. The cost of compliance section that begins on the bottom of page 5 and top of page 6 in the statement of need, we talk about the impact to state agencies and small businesses. We did determine that there may be additional costs related to compliance requests for, requirements for employers, both state plan and equivalent plan employers, to ensure that their model notice posters are in compliance with the rule amendments. And we also determined that small employers who use equivalent plans may, feel of a greater impact due to the increased reporting requirements. And we also determined that there would be a minimal impact on employers with for equipment, supplies, labor, and increased administration required for compliance with rule changes included with this batch. Regarding the effect on small businesses, these rule changes, all small employers in Oregon are subject to these rules, and we just wanted to acknowledge the most up-to-date data. Currently, there are about 109,000 small businesses in Oregon with less than 50 employees and 104,000 businesses with less than 25 employees. We did also address how small businesses were involved in the development of the rules. We are seeking feedback today from the Rules Advisory Committee, which has members representing small employers. And we will also email the draft rules to the email distribution list, which has over 117,000 people or businesses on it. And we have invited the public to attend the RAC meeting today. And we'll hopefully have a few minutes here to gather feedback from the public. And then additionally, we will enter the formal rulemaking process for the rules in November, and we'll have 2 public hearings in the middle of November. And that concludes my review of the statement of need. Do any of the RAC members have comments regarding the racial equity impact or fiscal impact statement?
I just say that it was well written and well thought out, so thank you for that.
Thank you. Appreciate that. Okay. Then I just I'm left with thanking our RAC members today for the feedback and the discussion. As always, it's really appreciated. Although we have been keeping track of the feedback, we would also request that you provide your feedback or suggestions in writing to our rules email inbox by the end of Friday, October 3rd. And also please feel free to add any additional thoughts or feedback, that wasn't brought up today. And this will help us before we enter the formal rulemaking process. And with that, I'm going to turn it back over to Jacob.
Thanks, Diavin. Really great job. That was a lot of rules that you had to go over in statement of need. So I just want to give you a quick shout out that was a really great job. We appreciate the brief summaries of the draft rules, and we also want to again thank the RAC members for your feedback and you attending with us today. This concludes our RAC member portion, and we have about 8 minutes that we can accept public comments. So we are going to allow public comments, feedback, that anything that wants to be provided regarding this specific set of administrative rules that are being changes are being made to them. If you have feedback, comments, or suggestions today, please provide today on these rules we just discussed. Please submit your name in the questions and answers section. If you can't find that, the chat section is available as well. When it's your turn, we will call on your name and we ask that you raise your hand. By raising your hand, we will be able to activate your ability to unmute. This would enable you to unmute your microphone so that you may proceed or provide your thoughts or feedback. Real quick, Brianna, I believe it's pronounced. If you scroll up a little bit, I did send a new link to the statement of need in the chat at 11:12 p.m. You did try both? Okay. If the links aren't working, they are available on the Oregon Employment Department rulemaking website, and I'm going to just grab that link for you real quick because that might be an easier way. That's where the document lives, at least. So, and while I'm doing that, I'm keeping my eyes open for any raised hands or names being put in to share feedback on today. If you try that link that I just sent, that'll take you to the OED rulemaking website. And then one of the first sections, it says paid leave Oregon proposed rule changes 2025. And the second item listed is our statement of need. Hopefully that works for you if you go through that route. Okay, I'm not seeing any hands raised. We'll give it a couple more minutes before we do closing remarks. That way we can give it like an even 5 minutes. I know it can sometimes be a little intimidating to speak in these webinars, so I do want to offer the opportunity for anyone who wants to provide written comment or feedback on these rules. There's an email on the current slide, rules@employed.oregon.gov. You can submit your feedback on these batch 14 rule amendments changes. And if you submit them by 11:59 p.m. on Friday, October 3rd, that we can include them with this round of editing. However, if you want to give feedback at a later date, we do plan to do our public comment period, which will host 2 RAC meetings in the month of November. And so with
Public
that,
hearings. Sorry, Jacob, you said RAC meetings. Public hearings.
public hearings. Thank you. Thank you. Okay, so the time is currently 11:21 or 11:22, and it's been about 5 minutes, and we haven't had any additional questions. So we are going to move towards closing our RAC meeting. Please provide your written comments on the proposed permanent rules, on these proposed permanent rules at the email address listed on the screen, rules@employed.oregon.gov. Thank you for attending the Oregon Employment Department's Rulemaking Advisory Committee for the Batch 14 Administrative Rules related to Paid Leave Oregon program. All feedback received today has been recorded to maintain the official record, as well as this webinar being recorded. This slide shows where folks can see the draft rules on our rules webpage. Paid Leave Oregon has a webpage that we keep updated up to date for employers, employees, and self-employed individuals and other interested parties. We are regularly expanding our frequently asked questions and providing answers, so please check that back often. You may also email questions about the draft rules to the rules inbox located in the third item listed on the screen, rules@employed.oregon.gov. If you have questions about individual claims or employer account details, please send a web notice through your Francis Online account or give us a call through our Paid Leave Oregon phone number. If you do not have a Francis Online account, you can also go to our website, paidleave.oregon.gov, and there's a Contact Us button up at the top where you can submit a Contact Us without having a Francis Online account. In addition to providing comments today at this Rulemaking Advisory Committee meeting, anyone may email written comments regarding these draft rules until the end of this coming Friday, October 3rd, at 11:59 p.m. to the rules inbox. Comments received after the 11:59 Friday, October 3rd deadline will not be taken into consideration before the proposed rules are filed with the Secretary of State's office. And so with that, thank you again for all taking the time out of your busy Wednesday and attending and participating in the Batch 14 Rulemaking Advisory Committee meeting. We really appreciate your interest and feedback. It is now 11:24 on Wednesday, October 1st, 2025, and the Rulemaking Advisory Committee meeting for the Batch 14 Paid Leave Oregon Administrative Rules is officially closed. We hope that everyone has a wonderful day. Thank you.
Thank you.